Depart Boying Remulla, sinagot ang ICC sa plano nitong makialam sa batas ng bansa. Ating abangan ang buong detalye, pero bago ang lahat, kung bago ka pa lang sa channel na ito, ay huwag kalimutang mag-subscribe para updated ka sa mga maiinit na balita sa Pilipinas. Walang intensyon ng Pilipinas na muling sumali sa International Criminal Court o ICC. Sinabi ng Pangulo sa isang briefing nitong Lunes na nakipagpulong siya noong nakaraang linggo sa legal team ng kanyang administrasyon na sina Solicitor General Minardo Guevara, Department of Justice Secretary Jesus Crispin Boying Remulla at Chief Presidential Legal Counsel Juan Ponce Enrile, kasama ang Foreign Affairs Secretary Enrique Manalo at dating presidential spokesman Harry Roque, isang kinikilalang abogado ng ICC na magsisilbing private counsel ngayon para talakayin ang plano ng International Tribunal na muling buksan ang investigasyon nito sa madugong kampanya ng gobyernong Duterte laban sa iligal na D. Nangako rin siya na magbibigay sa International Criminal Court ng mga detalye sa kampanya laban sa D bago ang deadline ng korte para sa gobyerno sa susunod na buwan.
How would we explain the position of President Marcos and yours regarding the lack of jurisdiction of the ICC on the drug war probe? Because some legal experts have been pointing out that under Article 127 of the Rome Statute, once the proceedings have started before the withdrawal took effect, then the ICC retains jurisdiction. So how do we explain that aspect?
It's just a practical consideration that we have to look at. No? When you withdraw from the ICC and you cease to become a member, then what activities can they hold in your country that will be sanctioned by your country as part of a treaty participant? Since you are no longer a treaty participant, you are no longer part of the ICC. So it's just logical that if you're not part of the ICC, the activities of the ICC will cease as far as your country is concerned. The jurisdictional issue then comes in, because if they want to conduct an activity in this country, it has to be sanctioned by the Philippine government. But since we are no longer members of the ICC, then what activities can be sanctioned when we're no longer part of that organization? So I think it's just practical, and it's just logical that once you withdraw from the treaty, then everything else that goes with it ceases.
So there's no room, Sec, that the ICC might resort to other means available to them to continue the probe?
To continue the probe, you need a compulsory process. A compulsory process means that you have people who will be taking oaths, and there will be a law in place. There will be the law of the state in place. So what law will they use when they start investigating in the Philippines if they will not pass through Philippine authorities? I think there's a change in circumstances already. We can no longer, there are two international law maxims that are applicable to this. And probably for this purpose itself, it's rebus sic stantibus, which means that there's already a change in fundamental circumstances, or fundamental change in the prevailing circumstances.
Good afternoon, sir. I'm Nancy Carvajal. Sir, there are reports this morning that the senators would try to ask during EDAC to reconsider the decision of President Marcos. And how is that? Is there still room for that?
We're a democracy. We have three branches of government. The legislature can always speak with the executive on this matter. And the person who will make the decision for us is President Marcos himself. Mm-hmm. So we're not closing the door to anything, especially dialogue with the Senate, since we have to work together to bring the country forward in the next few years, at least for the 6 years that the people have elected the president.
Follow-up, sir. This decision was reached because of President Duterte's war on drugs. So aren't we, as a country, depriving other countryman, if ever merong ibang kaso um, that would involve ICC for yung assistance?
I think that, first of all, you have to understand what the ICC is all about. No? It is the International Criminal Court, which was founded to run after individuals within a state, vis-a-vis the ICJ, which is put up to go against states themselves. So, when you have a functional judicial system, I think it's indisputable that our courts are functioning. The prosecution is functioning. We are here right now as part of the Department of Justice, which is in charge of prosecution of crimes, enforcement even with the NBI, corrections when you have to make people serve the penalty for crimes, correction services. We have the Bureau of Pardon and Parole, which are all internationally standard, no? And we have Parole and Probation Board. This means that we have a functioning judicial system. So I don't think that there's any deprivation involved here, since what is involved is domestic law and the way that we run our country. And it is a democratic country. The Supreme Court is fully independent of the executive, and the legislative is also completely independent of the executive. It is a functioning democracy. It is indisputable that we are a functioning democracy. So there's no deprivation involved. And if there are crimes that people want to be pursued by government, they can always go to the police, they can go to the NBI, they can go to the Department of Justice and the agencies under it, including the fiscal's offices in the cities and in the provinces. So we have a functioning judicial system. And the issue before the ICC is to run after criminals or people who commit crimes, and probably even crimes against humanity, if you want to classify them as such. So there is no deprivation at all. I don't see any, unless you can pinpoint something that you may wish to be discussed further.
Thank you, sir. Maybe later.
Thank you.
Hi, sir. Sir, of course, that's the line of the government.
Can you introduce yourself?
Sir, I'm Anjo po from CNN Philippines.
CNN.
Yes, sir. Sir, yung nga po nasabi na parang domestic mechanisms are working, but the drug war panel review of former SOJ Guevara yielded a few cases, and only a few have been filed before the courts. Now, how will you change that? How aggressive will be your under your term, the drug war panel review, considering that there are thousands of the drug war deaths involved under the war on drugs of the past admin?
I think I'd like to ask Undersecretary Raul Vasquez to answer for us.
Actually, good afternoon. Actually, there are many reforms that are being undertaken and have already started. The first one is actually the simplification of the appeals process, and that was covered by Department Circular number 27, series of 2022. And this means that the process would now be simplified. The cases that would be elevated to the office of the Secretary would be delimited to cases that are cognizable by the regional trial courts, while we have empowered the regional state prosecutors and the Prosecutor General as regional state prosecutor for Metro Manila to render decisions with finality on appeals relating to cases cognizable by the Metropolitan Trial Court. And we are happy to inform everyone, our country, that since we assumed office last July 1, 2022, upon the strict directive of our good secretary, we have been current. We're trying to make current all recently filed cases from July 1 up to the present, to finish them all, the petitions for review, within the mandated 60-day period of suspension of arraignment, in order to give life and true meaning to the administration of justice, focusing on indigent litigants, cases that are handled pro bono by lawyers and the IBP particularly, and cases that are handled by the PAO, Public Attorney's Office. There are many reforms that are still being thought out, and that would be implemented soon as all of us, upon the strict direction and guidance of our good secretary, hit the ground running, so to speak, because we knew the problems are. We've been, Jesse Andres and I came from private law practice, so we all know, and we've been confronted with these issues day in, day out since we started our law practice decades ago. Thank you.
Attorney Jesse Andres, Undersecretary Andres will also add something.
If I may add to that discussion, Mr. Secretary, if you look at the reason why the ICC may come in, it should be the inability of the present state of government to address the institutional requirements to attain justice. However, it's very clear based on existing laws and existing agencies and government instrumentalities that everything is being addressed at our own level competently and adequately through institutional measures. In fact, data shows that the institutional measures are working and that convictions are being done based on cases that have been filed in court. All the extra-legal killings that have been filed in court have been addressed by the prosecution, by the Department of Justice, through the prosecution service, and the courts have actually rendered judgment in several cases, and we can even cite numbers on recent cases where 18 individuals, uniformed personnel, were subjected to trial, and the court has rendered conviction, a judgment of conviction on the murder cases filed against these individuals who committed killings in the course of their work. So, in other words, there is nothing that the present system is not adequately addressing, and that institutions are working, and therefore we should leave it to the institutions within our government to address these issues.
But what will happen to the drug war panel? Will it still continue to exist?
We're still collating some data for the cases that have been filed. We are pursuing these cases. But, of course, the problem will always be the dearth of witnesses. There's always a lack of witnesses that are needed to be able to prosecute a case successfully. It would be easy to file 100, 200, 300 cases, but for them to be successfully prosecuted is another matter. If there are witnesses who want to come forward, I can assure you that we will take care of the witnesses and give them protection. And if that's what's needed. We have a witness protection program under our government right now, under the DOJ. It's been there, institutionalized. And for those who really want to come forward to be a witness in a criminal prosecution involving what you call extrajudicial killings, then please come forward. We will welcome these people who wish to put forward their testimonies. The work is ongoing right now. Maybe the other problem that we see coming also is the fact that once we look at the six terms, because there is a time-bound thing here. The last 6 years prior to our coming in is pointed out as the period for which we should investigate. But when we start answering those questions, then people will go back another 5 years to 2011 and say, oh, there were other crimes committed in 2011. What is clear is that it is a responsibility to pursue these cases as long as they have not prescribed, and the government can still run after the malefactors here. So we're just pushing through with all the investigations that are there, but I'm telling you, our problem really is a lack of witnesses. If witnesses want to come forward, we will welcome them and help them and pursue the cases that they want to testify in.
Mr. Secretary, in addition to that, the government has already adopted what we call a whole-of-government approach. It's a multi-sectoral approach, which does not only include the side of the Department of Justice, but also the side of private sector, non-governmental organizations, and media. And this whole-of-government approach is effective in addressing all these concerns on extralegal killings. It is, as you know, there are no more unabated killings as of today. In fact, record shows that there are no unenforced disappearances or torture in the last 3 years. And that means the government is in place and in control. So that is what we believe in, and that is what excludes the ICC from exercising its powers over us. Our institutions are intact and working.
Good afternoon, sirs. Lian Buon po from Rappler. Sir, how assertive and transparent would the DOJ drug war review be under you? Because in the past, the PNP would only share 56, tas they cut down pa nga to 52, and the DOJ can't seem to, assert its place to get more. The PNP, sir, only shared originally 56 case files out of the thousands, and then it cut it down to 52. And the DOJ can't seem to assert its place na kumuha pa ng maraming case files. And then whatever the DOJ had, it didn't share with the CHR because there were concerns with the security sector. So in your drug war review, how assertive would you be to get all the case files, and how transparent would you be in sharing what you get and what you have?
It's the duty of every law enforcement agent to turn over to us the case files. There's no ifs and buts there. So if they think there's a directive needed for that,
Yeah, this is the final result.
Mr. Secretary, if I may add, there is now a serious effort undertaken by the DOJ under Secretary Boying Remulla and the DILG under Secretary Benhur Abalos to have a joint and common effort to have a more efficient and productive law enforcement and prosecution.
Para naman sa inyo, ano naman ang masasabi nyo tungkol dito? Magkomento lamang sa baba at huwag kalimutang mag-subscribe para updated ka sa mga maiinit na balita sa Pilipinas. Maraming salamat sa panonood.